one of the things that we see on the benefit side pretty regularly, believe it or not, is 5500s on the health and welfare side. So employers don't realize, I may only have 90 employees on my medical plan, but I have an employer paid life policy that I have 150 employees on that plan, and they're not filing a 5500 form. So there's a lot of moving pieces around compliance. You need to be aware of it, because if you get caught, it can be pretty substantial. So Matt and Stephanie, nice job. Thank you very much. I'm now going to bring up Eric Meyer. Eric's going to talk about some stuff that's pretty timely right now.
Hey guys, I'm not going to be as fun as everyone else talking about tax. Whoops, what are we doing here? We're gonna talk about marijuana. We're gonna talk about politics. We're gonna talk about flipping people off. It's gonna be real fun. All right, gang, you ready? Here we go. Yeah. All right. Medical marijuana in the workplace, right? I assume you guys have this all under control. Here's what I want to know. Oh man, what am I doing here? All right. Thank you. I'll learn this one of these days. Here's what I want to know. We've got April 20th, 2016, Governor Wolf signs Pennsylvania's compassionate care medical marijuana. I don't know what's going on.
Must be the marijuana.
Could be. Could be. I'm going to put it down. Thank you. Governor Wolf signs Pennsylvania's compassionate care law into effect. What I want to know is, if it's not legal here now, and they want to start growing it, how do they grow it, right? Anyway, I actually know the secret to that. I represented folks in New Jersey who have dispensaries, but yeah, here's medical marijuana coming into effect April 20, 2016, but there is no medical marijuana yet in Pennsylvania, right? We just signed it into law. What does the law say? Let's see if I can do this right. One touch. Perfect. Okay. What does it say? This is what Still, is it? All right, great. All right. Here's the basic tenets of the medical marijuana law that employers need to know, okay? First, you can't discriminate against someone because they have a card. Someone's going to sign up for a card. They're going to have one of about 17 or 18 conditions. They can become registered to procure medical marijuana. Hasn't moved yet? Good. It's out of my hands? Great. Okay. They get a card. You can't discriminate against that person as an employer because they have a card. You ask them in a job interview. I don't know why you'd ask them in a job interview, hey, do you have a medical marijuana card? But if it happens to come up, okay, you can't discriminate against them on that basis. Now, I know what some of you are twisting your handlebar mustaches. You're being so devious. Okay. You ask, it comes up, they have a medical marijuana card. You say, I'm not going to discriminate against you, no problem. Yeah, but you have to take this drug test as a condition of employment. And the drug test comes back positive. What can you do at that point? I'm going to leave you in suspense for a few minutes, okay? We'll get back to that. The law says that you can, although you don't have to, accommodate an employee who uses medical marijuana. So let's take a step back for a second, right? We have a couple of laws, federal, state, local, disability accommodation laws. Federally, we have the Americans with Disabilities Act. At the state level, we have the Pennsylvania Human Relations Act, and here in Philadelphia, we have the Philadelphia Fair Practices Ordinance. And each of these laws say that an individual with a disability, and the bar for what counts as a disability is very, very low. If you have a hangnail, you probably have a disability under one of these laws, okay? A qualified individual, that is someone who can perform the essential functions of their job with or without an accommodation. That accommodation is perfect. That's the key word. You have to do something for that person. So if there's a reasonable accommodation that exists to allow someone with a disability to perform the essential functions of their job, then you have to provide it. Okay. There's nothing under federal law, under the Americans with Disabilities Act, that says that employers need to accommodate an employee's use of medical marijuana. Okay? That's clear. talk about that. I'll get into a little bit more detail in a slide or two. Maybe it'll advance by itself. No, I guess I'll probably have to use the clicker. But there's nothing that says that you have to, okay? But what the state law here says is you can. You can. Now, let's talk about two different situations, right? You can, might be worthwhile to do it for someone who works a desk job, not going to be a safety risk themselves or others, versus someone who's working around heavy machinery, driving a truck over the road. There are other federal laws that say you just simply can't, right? Marijuana is a Schedule I drug. Federal Department of Transportation regulations say that someone who is like an over-the-road trucker can't test positive for drugs, whether it's medicinal or not. They can't be using marijuana. But in certain situations, you may want to think about accommodating. Contrary to popular belief, medical marijuana isn't going to bring you back to college with a 4-foot bong and a bag of Cheetos, okay? It's not really like that, okay? Sometimes it's used for pain and it'll give you that high, but oftentimes it's used to treat tremors, seizures, Parkinson's, epilepsy, and it doesn't have that high effect. And most people who use medical marijuana are using it, let's say, out of the workplace the night before to control pain, seizures, like they would any other prescription drug, and then show up to work. So think about that. The final thing about the Pennsylvania law, it says you needn't violate federal law. So that example I gave about adhering to Federal Department of Transportation regulations, someone who drives as an over-the-road trucker, you don't have to accommodate their use of medical marijuana because Department of Transportation regulations say that they can't. All right, I'm going back to the clicker. This is dangerous. One time. Okay, real quick. Okay, this is when all the licenses came out, right? June 20, 2017, the licenses to dispense, grow, were awarded, and there have been about 140 appeals filed. So no one's growing anything yet. No one's dispensing anything yet, okay? People can sign up to get that medical marijuana card. The latest projections are like, early 2018, we'll start dispensing medical marijuana, but June 20, the licenses came out. So, duty to accommodate. I never thought I'd have the opportunity to put Biggie and Tupac into one of my presentations, along with Magic and Bird. It's an East Coast, West Coast thing, right? Why do I have Biggie and Tupac in one of my presentations? God, what was I thinking? Okay, here it is. East Coast, West Coast. Anyone who's familiar with HR, especially employment law, especially if you work for a multi-state company, know that out in California, the laws, I see some faces, some knowing nods, the laws are so employee friendly. And here on the East Coast, West Coast is employee friendly, California especially, Washington, Oregon, Hawaii. Here on the West Coast, on the East Coast, not so much, right? Pennsylvania, very employer friendly state. Jersey's kind of like the California bee, so that's an exception, but generally it's pretty employer friendly over here. For medical marijuana, it's flipped. It's strange. I said duty to accommodate. California, the state and federal courts have said there is no duty to accommodate an employee's use of medical marijuana under either state or federal law, period. Washington, same thing. Come over to the East Coast, it's different. Rhode Island has said, yeah, there's probably a duty. Massachusetts has said that there's a duty, even though the state law in Massachusetts says nothing affirmatively about a duty to accommodate. The court read that into the law. Okay? Connecticut, same thing. In New England, they say it's a wicked pissa, right? That can either be good or bad, depending on who you are. Okay? Still not sure. I've watched Good Will Hunting many times. I'm still not sure if that's good or bad. Wicked pissa. But in this case, the trend on the East Coast is that there is a duty to accommodate employee use of medical marijuana. Now I know some of you have the question, what does that mean? They can come in and just light up and start taking gummy bears and all that kind of stuff? No. It means that they can use medical marijuana at home, like the night before, and show up fine the next day like any other prescription drug, and you would have to accommodate that, right? If someone's in a safety sensitive position, you don't have to let them use marijuana if they're going to be a threat to themselves and others. It's like any other accommodation, right? Think about how the Americans with Disabilities Act works, okay? You accommodate someone reasonably. If it's going to create undue hardship for the employer, you don't have to do it. So the same rules would apply in those states. And maybe, who knows, we'll see what a Pennsylvania court does. In New Jersey, there's a case pending on this. We'll see what happens, okay? So basically, the takeaway for 2018 is, well, I don't know what to tell you, other than keep an eye out for this. This is just a developing area of the law, and wow, I got to use Biggie and Tupac. Okay, 24/7 social media and off the clock. I'm going to put this down. Here's, I don't know. Let's just go. I mean, really. Here we go. Let's just skip to here. Natalie Monroe. Natalie Monroe is she's the original. She's the OG, right? This was a teacher in the Central Bucks School District who had this little blog a couple years ago, a little private blog where she would talk about recipes. It was closed off. It wasn't public. It was just for her friends. It was very mundane until one day she decided to talk about her students. And she didn't call them out by names, but basically it was a blog post about, if you can't see the print here, if you don't have anything nice to say. And she talks about scores or comments that she wishes she could have put on students' report cards, like most likely to engage in a Columbine-style shooting. What? Like, you're a dunderhead. I mean, it was all kinds of crazy stuff. Well, what do you think happened, right? Somehow, mysteriously, this private blog got leaked to the press, to the school, you name it. She was suspended and ultimately fired. An anecdote to this is one day I get a phone call from a lawyer saying, hey, I'm going to represent Natalie Monroe. I blogged about this many times, said how stupid she was, how crazy she was for doing this. I get a call from a lawyer saying, I'm going to represent Natalie Monroe in a First Amendment case that we're bringing in federal court in Pennsylvania. And I said, Stephen, is that you? It was my stepbrother. Representing Natalie Monroe. He ended up losing. And that was the myth. The myth here is that there's some right to free speech. That employees, even in the public sector, have some right to free speech on social media. You kind of do, but not really, right? If you're going to engage in inflammatory free speech that's not on some kind of public issue, you don't have a right to free speech. She claimed it was a matter of public concern because she's talking about the school system and the quality of our schools. The school defended that by saying, but look, you're completely hindering the way we operate. Like, you can't come to class having made those comments and teach our students. It doesn't work that way. And the court agreed. Let's see. Charlottesville, right? Charlottesville, real quickly. We know what happened in Charlottesville. This dude lost his job at a pizza shop. This dude lost his job somewhere. That one right there. You know, we had someone who worked here at Dilworth in our IT department. He no longer worked here by the time of Charlottesville, but he identified himself on his Facebook page as being an employee of Dilworth Paxson. He was outed as part of Charlottesville. We had no idea. It's not like you ask someone, they come in, hey, are you a white supremacist? We didn't know, right? But when he was outed as part of Charlottesville, remember on Twitter, there were people trying to out folks who were marching in Charlottesville. This was one of the people who was outed. And our firm started getting tweets and phone calls and emails about, hey, did you employ this person? What kind of firm were you? And it was all because this person, who we'd fired a long time ago, had this still on his Facebook page. He identified himself as an employee of Dilworth Paxson. People were able to draw that connection. So we got ahead of it. We issued a statement. We said this person is no longer employed here. It's completely abhorrent to our value system here at Dilworth Paxson. The point of all this is that what people do on their own time, off the clock, so to speak, has an impact on the workplace. It had a profound impact on a number of workplaces, including ours. And we did something about it. So employees are responsible for what they do, not just on the clock, but off the clock. Trayvon Martin. Here's a guy, this guy Todd Snipes. He He was he reminds me of like Mitch Buchanan from Baywatch. I think he was a lifeguard or a beach guard or something like that. He posted on Facebook, "Another thug gone, pull up your pants and act respectful. Bye-bye thug, R.I.P." This was the day of the George Zimmerman verdict. He lost his job. He sued, claiming some kind of First Amendment violation. And the court, the 11th Circuit, reached the same conclusion that the court did here in the 3rd Circuit about someone who works for a public entity who says really inflammatory stuff that affects their ability to do their job. The guy's basically a cop, a beach cop. A lot more racist apparently than Mitch Buchanan. Probably not as good of a following in Germany for Mitch Buchanan's music, for David Hasselhoff's music, but still, he lost his job. You know, he can't come to work. People aren't going, you know, imagine you're on the beach, you're drowning, and you see this guy. If you're not white, you're going to be concerned, right? That's why this guy lost his job. Here's the exception. The exception is protected concerted activity. Okay? Protected concerted activities is under the National Labor Relations Act. Covers employers that are unionized and a lot of non-unionized employers too. 2 or more people, generally speaking, who get together, come together talking about working conditions, they are protected. Even if they get on social media and bash their boss, that's generally protected. So if you fire the whole lot of them because you learn one day in HR that all these people are talking smack about the employer, even using bad language, you know, at the end they can say vote union. They don't even have to say that on their Facebook post, but if they're getting together and talking about working conditions, there's a lot of protection afforded them. That's the exception to the rule, okay? But you know, expect that may change going forward, because now we have, I'll get to you in a second. Now we have a new complexion at the NLRB. It's going to become more Republican, okay? Probably more business friendly, but right now, you know, education, training, narrow social media policies, nothing real broad, just narrowly tailored to address what employees need to know. Employees can talk about salaries online. That's not confidential, right? But if you have a policy that says that employees are responsible for what they say and do online, and you know, if someone engages in discriminatory behavior on or off the clock, then they can be terminated. And stay updated, because we are going to see some changes in the law with the new National Labor Relations Board taking over. All right. This was my godsend. This woman, old Julie here. Julie was snapped about a week ago, giving the middle finger to Trump's motorcade as it was pulling out of one of Trump's golf clubs. A White House photographer caught this. I prayed to the gods of Tuesday morning PowerPoint presentations when this came out, because I updated my PowerPoint presentation yesterday. This is a woman who was snapped by the White House photographer flipping the bird to the motorcade. This photo went viral. It was talked about on late night television. There was a hashtag for her. I think it was like her 2020. It was all great. Turns out she works for a government contractor. Oops. And she went to the contractor and said, "Yeah, that's me." And they said, "Well, you don't work here anymore. You're fired." She claims that there was another male employee who said something on Facebook, that something about libtards, and it was pretty inflammatory. And the company was allowed the male employee to take it down, and they fired her. And so people are saying, well, is there some sort of discrimination there? And I say no. I say no because he didn't become a late night star. Didn't draw the same publicity that she did. But yeah, I mean, that's another issue for employers to consider. Make sure that if you have a policy on social media otherwise, that you're enforcing it evenly. How are we doing on time, Dennis?
Good.
All right, awesome. All right, now why don't you flip to the next slide for me? Oh, there we go. Okay. Gonna do it again? There we go. Okay, the natural segue into our politicized workplace. Okay, I got a call a couple months ago, and I've gotten other calls like it, from clients saying, "Eric, have you heard from employers, noticed anything different about our workplaces since the 2016 election?" I said, well, you don't say. Yeah, I have noticed some things different. And this isn't meant to be a direct shot at our president. I think it's more kind of the environment in which we live. It was a very charged election, a lot of emotions, okay? A lot of strong feelings on both sides. Some of those strong feelings were shared respectfully, some not so much. But think about the issues that are attendant to the election. Build the wall. Let's talk about building the wall. What were some of the first stories we heard about after the election? There was a kid out, and I think it was it Council Rock School District, who found in his or her backpack a note that said, "Go back to Mexico." Okay. We saw videos and Facebook posts and things like that about employees talking about building the wall. So, people, their coworkers who are Hispanic would have to go back to Mexico, right? That's that slippery slope. Building the wall is a political issue. There's nothing discriminatory on its face about that, okay? But then you take it to the next level, and yeah, there's that slippery slope. What are the pub rules, right? What shouldn't we be talking about in the workplace? Politics and religion, okay? Those are two good rules to extol. Unfortunately, it's really tough to enforce that. And when you have political discussion at work, okay, you're going to have a slippery slope into discussion about protected classes, race, religion, national origin, gender, LGBT status, things like that. These are political issues that can be polarizing and can slowly slip into a hostile work environment claim at work if the discussion becomes less reasonable and respectful and just more inflammatory. There's Travis Kalanick from Uber. He didn't have a great 2017. Whether it's, and I hesitate to lump them together, but the former CEO of Uber and now Harvey Weinstein, and just this trend now, unfortunately, that we are seeing so many allegations of sexual harassment, unequal treatment among gender. Not at the lowest level, okay? I mean, we've had that since 1964, and prior to that, when Title VII went into effect. But now we're seeing a spotlight on the C-suite, this bro culture, okay? And the point of this is your culture starts at the top, right? And it's a difficult conversation for folks in this room to have in the workplace. Many folks here are from human resources. How do you have that conversation with your boss? Hey, boss, you need training, You need training. But as HR, our job is not only to look out for employees, but also employers, okay? And that's protecting the workplace, okay? So it may not be one particular boss who needs the training, but for the benefit of the company, there may be someone at the C-suite level who, you're only as good as your worst player, who may be part of that bro culture. So now is as good as any to think about not just, you keep doing that training, that respect in the workplace training of your managers and your employees, but think about really expanding it to go up to the C-suite, okay? All right. Rules of the playground. All right, go ahead and advance. All right. Rules of the playground. Why do I put this up here? Nothing's really changed. I mean, we have the election. That's changed. We have a new president. But the rules of work, Title VII, still the same, right? The law sets the bar. So even if people say, get a thicker skin, I don't have to be politically correct anymore. Well, the law says you kind of do, right? You do have to be fairly politically correct. You can have discussion, respectful discussion about politics or anything else. But once you cross that line, once you engage in some behavior that is because of someone's gender or race or religion, it's severe or pervasive, it offends them, so on and so forth, you got a hostile work environment. And again, not trying to make anyone in here a lawyer, God forbid, but one time, you know, you know the drill. One time in your workplace is too much. We encourage people to complain after one incident. So if someone is offended, you know, complain. Take all complaints seriously. Continue to do that, especially in this environment. Don't trivialize anyone who complains. Make sure your managers aren't part of that culture where they say, hey, get a thicker skin, right? Toughen up. This is where we live now, okay? Now, starts at the top, but make sure on its way down that people know that if someone feels as if they've been discriminated against, reasonably, they feel that way, then make sure their voices are heard.
Eric.
Yeah.
Eric.
Yeah.
Can I have a minute?
Yeah, sure.
Hi, I'm Barbara Olson, I'm a partner here at Dilworth. Two things. First of all, I want to go to this one, but back one step. The C-suite, they need to be trained more than anybody else because the C-suite is older, they are more male, and they really need to be trained. So don't even think about excluding them. Give them extra training. They really need it more than anybody. One thing. The other thing, with respect to, sorry, I just lost my train of thought.
I'm sorry.
We were just talking about.
The rules of the playground and that taking all complaints seriously.
Oh, okay. I'm aware of a situation where somebody at work kind of complained to friends about somebody having said something completely inappropriate, making this woman very uncomfortable. Those friends took it to the top, whatever. And the person who was offended actually said to the senior person, I'd rather not bring this up. I'd rather we not take this any further. And the senior manager had to say, no, we have to. We need to address this. I know you'd probably feel more comfortable if we didn't go to the person who was so offensive and deal with him. But you know what? We need to have a work environment where there's zero tolerance. And so even though the person who was, you know, subject to the abuse would have been happier to keep it quiet, the right thing for the company to do was to go and do the reprimand and do the tough conversation.
You're going to get sued. It happens, and that's what the insurance is there for. And you'll be thankful that you have it. One selfish point: if there's a particular lawyer, hint, who you'd like defending you in those EPO cases, make sure that in your policy you have that endorsement that says that you don't just have to use panel counsel, but you can use the attorney that you want. Okay? And with that, Dennis.
Nice job. Thank you, Eric. Very good.